All right, looks like we have a critical mass, so we will go ahead and get started. Thank you guys all for joining us. We are here to talk about legal considerations for public-private partnership governance in global health. And we're going to do things a little bit differently today because we had a topic that we really wanted to make interesting and come to life. And because we have a panel full of lawyers, we're going to take them back to their law school days. And rather than structuring it as a panel discussion, we have a fact pattern, which you guys should have in your materials, but I'll go through it as we progress. And the real intention behind this is to put you all in the minds of your respective lawyers, what they are looking for as we structure these partnerships. So I think we probably, from a programmatic side, are thinking about things quite differently than the lawyers might be. So we're really going to try and pick out those issues that they would look for as we put together these partnerships. So we've got a wonderful panel today. I'm going to introduce our panel, and then the rest of the time we've sort of created a hypothetical anonymized situation. So no one's going to have to speak directly on behalf of their organization, but can more generally speak on how they might think about things. Let me start with introducing who we have here today. We have Douglas Brooks, who has recently joined Gilead Pharmaceutical Company as the Senior Director for Community Engagement, and he is coming from the White House, where he served as Director of the National AIDS Policy. We have Anthony Brown, who's the counsel at Gavi. We have Kenneth Miller, who's counsel at the Bill and Melinda Gates Foundation. We have Matalon Nathani, who has her own law firm that represents several NGO and implementing partner clients. And we have VALERIE WENDEROTH, who's an attorney at the U.S. Department of State. Great. Do you guys want to say a word before we get started, or do you want to jump in?
I think we can just jump in.
Okay, great. All right, so here's the scenario that we are going to be working with today. We have a pharmaceutical company who has a relatively new drug that's used for vaccinating children. We have a philanthropic foundation, not to be named, which makes strategic investments in children's health. We have a multilateral alliance who represents country governments and their ministries of health and is the lead coordinating body for global vaccination programs. We have an NGO who implements programs on the ground. And we have the U.S. government agency who has an office dedicated to setting policy and providing foreign assistance for children's health. This office happens to provide funding to the NGO to implement programs on the ground and has a seat on the board of the Multilateral Alliance. Now, the scenario today is that this pharmaceutical company wishes to make a drug donation of vaccination for 1 million children in sub-Saharan Africa. And they want to do so in partnership with a consortium of organizations that have a similar vested interest in children's health. So all the organizations have the same end goal in mind. They all want to vaccinate 1 million children. So they agree to come together in a public-private partnership. So my first question kind of refers back to Michael's earlier points is, what does it mean to be in a public-private partnership? It's sort of a term of art. It's one we've heard today doesn't work so well for everybody. But how does it differ from a joint venture or a corporate deal structure or other similar arrangements where you're bringing people together?
So the first thing I want to say is that I am not an attorney, nor do I play one on TV. I am a social worker, and I think that's an important part. It's good to have us on panel. So certainly in our company, and I think it's fairly standard because we're highly regulated, there's a firewall between our commercial/business activities and our corporate, read public affairs, government affairs, medical affairs activities. So that's just inherent in our day-to-day operations. And then we have within our corporate public affairs, grant making, community engagement, we have various types of public-private partnerships. So we might just do straight out grant funding and support something, or we, as a matter of fact, might just donate drugs, for instance, for the very large IPREC study, which looked at pre-exposure prophylaxis, which was an NIH-run study. Gilead donated drug for that. Or we might actually give funding to buy drugs, such as with the State Department PEPFAR DREAMS project. So there are various ways, but for a joint venture where we might decide to bring to market a drug with another drug company, that would be a highly regulated, highly structured thing, or even a corporate deal structure where, for instance, we at Gilead just acquired another company very recently, that a whole different set of legal implications and dynamics.
Kenneth, any thoughts on this?
Well, I think that, first of all, I think I like the term partnership. I know we were talking about that earlier because these can be structured in so many ways. I mean, when I think about the types of transactions and deals we put together, I think that was a great slide that Michael used earlier, that they can range from contractual joint ventures to actually starting a new entity to more loosely defined relationships. But I guess what they all have in common in this sector is that that they have a charitable purpose, that the mission is to impact and improve the lives of the target beneficiaries. And I think that's probably the common element, regardless of how you structure or define these things. And so because that's the mission, that obviously is a different mission than typically for-profit partners are engaged in, where they're commercializing a drug mainly for high-income markets.
Great. All right, so I'm going to move on to our scenario. We've decided that we're going to create this partnership, and we're going to memorialize it with a memorandum of understanding. And the MOUs, in many cases, are non-binding for partnerships like this, but nonetheless, they lay out the roles and the responsibilities of each of the entities who make up the partnership. Anyone who's spent time in a law firm knows the first step to any deal is due diligence. You start researching the parties you're getting into business with. So in this case, we do a little diligence, and we learn that the pharmaceutical company was recently involved in litigation related to their business, their commercial operations. We learn that the government agency's Undersecretary for Child Health happens to own stock in the pharmaceutical company. And we learned that the president and benefactor of the Philanthropic Foundation is on the board of the NGO. So with each of these factors, I want to talk about the ethics determinations that may create a conflict of interest, how you evaluate those, how you weigh the relevance of those issues as it relates to the value that entities may add to the partnership. Does it preclude the value to partner, or can you recuse yourself, as they mentioned in the last panel? I'll put that out to anyone who wants to weigh in.
So I think, let me take the third element of it, and that is more of the conflict of having the president and the benefactor as part of the NGO. So I think that, conflict of interest it can be very challenging for all of us. But at the Gates Foundation, we don't, it's not binary that there's a conflict and you can't be involved. What we try to do is we try to weigh the risks against the reward. So in thinking about this scenario where the president is on the board of the NGO, some of the benefits would be in terms of accountability, because you would have more insight into how the funds are being used. There would be more transparency because you would actually hear the board deliberations. But on the other hand, there's a whole potential for some different risks. So one of them, for example, is that the president would have fiduciary duties to both the foundation and to the NGO. And that can be something that can be very difficult to manage. So you could think of a situation where, for example, we enter into the MOU and eventually it turns out that this work is not creating impact, it's not on mission, it's not on strategy. That makes it much more difficult if our president is on the board to change strategies. So that's one thing that we'd be concerned about. And there's also issues of confidentiality. The president's going to have confidentiality obligations to both the NGO and to the foundation, and can that information be shared? There's reputational risks for the foundation if, for example, people perceive it as favoritism to that NGO. And so there's a whole host of those sort of negative things that we try to weigh against the positive. And I think we often are very intentional about looking at these situations and thinking about, if our objective is to achieve impact, what is the best way to do that in this scenario? And maybe in this scenario, the best way to achieve impact is not to have the president on the board, but maybe to be a non-voting board observer, or to provide other ways to create transparency and accountability.
Maybe if I can just add a bit to that. First of all, thank you for inviting me. When I was asked to speak initially, I was like, yeah, sure. And then I was told it was about public-private partnerships, governance and global health. And I was like, oh my God, what am I gonna say? I have no clue what governance means, and I don't know what public-private partnerships mean. But I'm pleased to find that no one else does. So, and as Mark said earlier, if you ask an academic to speak on something, he'll find something to say. It's doubly true for a lawyer. With that said, I would say that when it's very interesting when you start talking about conflicts and ethics in this environment, because scary music starts playing and everyone turns and they look at the commercial entity in the room. There's this collective fiction as if there are no other conflicts. And of course there are. As Mark said, they're filled with conflicts. Everyone from the multilateral organizations who receive funding, the implementing organizations that receive funding, the funders, although I know I can't call them funders anymore, but I have to find something else to call them, those organizations, there are all types of conflicts. And there are double conflicts, right, as well. So you have the individual's conflicts, and this fact pattern brought out both the individual's conflicts, and you also have the organizational conflict, right? And we often do think a little bit about the organizational conflict, but we sometimes don't give enough thought or thinking to the individual conflicts in this environment. And then when we think about the organizational conflicts, it's the commercial entity, because the others are kind of less conflicting, right? Because they're thought of as, oh, they can be managed, and they're looked at less negatively. So when we think about conflicts, we have a lot of conversations around how do we manage conflicts in an environment where everyone, or a number of stakeholders, are receiving funds or have other aspects about their role that is also a conflict. And sometimes how do we create a situation where we have a balanced approach? Because when everyone is looking at the commercial entity in the room, the commercial entity is looking at everyone else in the room and saying, well, why are you looking at me? You guys are just as conflicted. So those are just some of the considerations that we think about and some of the things that we need to weigh when looking at this.
I think this point came out in the last panel as well, is that certainly from a programmatic perspective, conflict gets very tricky because you want people who are knowledgeable and experts and committed and involved. You don't want people who are so outside of the realm as to not have a vested interest. That's what makes a program successful, is when you have people knowledgeable. But I guess it's the interest piece is aligned. It's when it's a conflict that you have to do the balancing act that you're speaking to.
And someone said this earlier. I mean, sometimes the only thing that's necessary, and I think to Ken's point of being intentional, sometimes what's necessary is simply to state and disclose the conflict, and just have that be on the table, being thoughtful about it, and also, you know, to your point, also. The commercial entities, and especially in this case, a pharmaceutical company, is so regulated that there are many things in place, many laws, many practices, regulations in place to control those conflicts. And at the same time, you know, having a pharma company on a board, a representative from a pharma company on the board, have to be very careful that we're not doing anything that looks like we're trying to induce, that we're trying to get business for ourselves, even from the most well-intentioned approaches.
I would just add, and maybe this is an obvious point, that when my clients start talking to potential partners, the first thing they do is execute non-disclosure agreements. So if there's any issues of confidentiality, the parties who are participating in the discussion will at least have that piece of paper that they've all executed. And I also think, to what Ken was saying, it really is in sync with the principle of transparency, and what Douglas just mentioned as well, that everybody needs to be disclosing what these potential conflicts are so that the members of the potential partnership can weigh the value, the cost-benefit analysis of moving forward.
And it's interesting because coming from the federal government side of it, we talk about conflict of interest from a completely different viewpoint. We don't, well, I don't want to say we don't care, but the first thing that we look for is internal conflict of interest with, does anyone within the department have a relationship with a potential partner? Because we are required to distance ourselves from the private sector, and we can't have either an actual or even a perceived conflict of interest in terms of any financial gain that a person within the department might have with that partner. So with the second prong of this, the undersecretary of the office at the agency owns stock in one of the partners, is problematic. And I would make it a challenge for that undersecretary to even participate in this partnership unless certain things happen before we even go out. And I don't know if I'm sharing secrets or not, but we have a whole internal process within the Department of State that we can't even engage in a formal discussion with potential partners until we have internal agreement with the lawyers, the policy department, and then what we call the seventh floor, the really important people in the department, because everyone has to understand what it is the department is attempting to engage in. And so we wouldn't even discuss anything with any of them until we came to a conclusion on our own side as to what those conflicts are.
And maybe just a final word from me about ethics. A lot of people often associate conflicts and ethics, but I see them quite different in that ethics can lead to violations, ethical violations can lead to malfeasance, jail time, and are very hard to manage, right? You just can't manage poor ethics. You can have a policy to say what are the ethics of our organization, while conflicts, as we've been saying, can be managed. And I just think it's important to think about as organizations construct sort of an ethics policy and a conflicts policy to keep those two separate. There's certainly some interplay between them, but to view them quite differently.
That's an excellent point. And I think it speaks to transparency. I think it speaks to what you would disclose to the other parties. Certainly, you may not open up your financial books to the way you would if you were about to acquire a company. But I do think some of these relationships and some of these possible conflicts of interest should become part of a disclosure process to increase the transparency. Great. All right, I'm going to move us along to the next question. So one of the tenets of a memorandum of understanding is usually to lay out the contributions of each of the partners in the partnership, whether that's a financial contribution or an in-kind contribution of staff time or product. So in this case, the pharmaceutical company wants to value the research and development that they put into developing the drug. Sorry, I skipped ahead a bit. And so I wanted to get a reaction from the other folks of how you value what each person is putting in. Is it reasonable to value all of the research and development time? And what does valuation mean? Do the parties have equal seats at the table? Does the amount of resource contribution you put into the partnership somehow equate to the amount of voting power that you have in the partnership?
I can, one, it drives me insane when Lauren uses the word contribution, because I don't know if you looked at my bio, but one of these things is not like the others. I'm actually the department's fiscal attorney, so I deal with the money that comes in and the money that goes out, and contribution is a very bad word. Because we need statutory authority to make contributions. So when we look at where, and it doesn't happen all the time, where a partner wants to value what each entity is bringing to the table, we try to push them back and say, what is our role? How can you value a role? But if there is this valuation, because it depends on how much control that you have on a secretariat or some sort of governing board, I think that we as the federal agency would try to step away from that valuation and let the private sector, which, I don't know, someone said that NGOs are part of the public sector, and again, I also never ever considered that NGOs part of the public sector. It's us against everyone else in the room. So when the non-federal government partners are trying to do this valuation, at least from our standpoint, I think we push away from the table and say, you guys work it out, we're coming. And we also, and maybe this is why no one likes us, we tell them what our participation is. This is our role. If you want us on the partnership, then this is what we're gonna do. So it might not be a level playing field.
I think this is one area, at least from the foundation perspective, that really differs from a private sector deal. So if a venture fund or some other investor were investing in a company, their control, the number of shares they own, would be proportionate to the amount of funding they're putting in. I think at the foundation, from our perspective, we sort of look at the overall cost of the project and how much of that we're funding may impact how we want to think about global access, which is how we think about achieving our charitable mission, or what role, how involved we want to be, and what other players should be involved. But we don't go through a process of saying, just to use Gilead, Gilead is contributing X million dollars, we're putting in 500,000. It's not. It's at a much higher level of just sort of relative. It influences how we might structure the deal, but it's not a critical component of it.
I think partnership may be another one of those words that we add to the nomenclature. There's so many uses of the term. So when we think about the strategic element of the public-private partnership, Gavi doesn't necessarily value what each partner brings or the stakeholders bring. There's no need to do that because we're all trying to achieve the same goal, and we don't have a differentiated voting mechanism. However, we do have these things that I call opportunistic partnerships. And they are, and maybe I'll have an opportunity to explain them later in more detail, but there are these situations where we partner with a commercial organization or an NGO to achieve something very specific. And in those instances, we have to value what's been provided to us. And we have had instances where vaccines have been donated. We've had instances where services have been donated, consulting services, employment services. And we've had instances where just random things have been donated that we didn't even know we needed. Mobile telephony, for example. And in those instances, we use very commercial means to value those things. There are rules around this in U.S. GAAP, generally accepted accounting principles, and in general, you just use a market determination. So if you're trying to value vaccines, they can't just out of the blue insert all of their R&D, but all of their R&D is incorporated in their price. And Gavi, which has a policy on vaccine donations, says very specifically that we use the publicly available data that's posted on UNICEF's website, for example.
From our end, we calculate there's a formula for calculating fair market value. So, we go through that process. And then even as we're looking at working with organizations, we have, and it's just an in-house rule, that we're going to look at the other entities' budgets. And we're never going to be more than a small percentage of anyone's budget where we're making these investments. I would, something hearkening back to the opening and the first panel, and speaking about U.S. government. So I spent 20 years of my life in large nonprofit in Boston regional organization. I went to work at the White House, and at the nonprofit, we certainly had a general counsel and we had outside counsel. I go to work at the White House, and there's the White House counsel, there's the Office of the General Counsel, there's having to work with DOJ at different times, all these things. I thought I had worked with, it was like, oh my God, I've never worked with so many lawyers in all my life. And then I go to work for a pharmaceutical company and pales in comparison. But I think in the previous administration, there was a real commitment, both from the President and the First Lady, to public-private partnerships. And really looking at how those come about, it is, and it was stated earlier, there's this us against them piece. There are people who are there who are in place to protect the president, to protect the government, to protect the United States. It's really, really hard. And I know at some point this afternoon there will be a discussion about the DREAMS project. And Ambassador Birx, Deborah Birx, and I were there at the same time. We were the DBs, DB1 and DB2, and taking no credit for DREAMS whatsoever. But a piece that I feel like was missing very explicitly in the transparency and accountability conversation was leadership. That there has to be a driver of these things, and it has to be someone who is committed, who is thoughtful, who understands systems, who understands how to move those things, who's willing to call the other DB and say, hey, do you know why this is stuck here? Can you help move it to the next stage? I think all of those pieces are important in advancing what can be very feel-good and well-intentioned and important relationships, partnerships, however we want to say them, but things that are really difficult to bring to life.
It's a great point, especially in the context of this discussion, because quite frankly, it doesn't lend itself well to a term in the MOU. You can't say someone at your organization must be a champion and be excited about this partnership no matter what, even if you have a leadership change. So you can't legislate a champion, but it is a key component of a partnership. All right, I'm going to take us back on track on our fact pattern. We're going to talk a little bit about intellectual property. As part of contribution to the partnership, the Philanthropic Foundation is going to provide funding to the pharmaceutical company to adapt their drug compounds to make them more fit for purpose in developing countries. who owns this intellectual property, which in this case would be the drug compound that's kind of been adapted with funding from the philanthropic organization? Is it retained by the pharmaceutical company, or is it made part of the public good?
So I chuckled. I came into this process later than most of these people. I chuckled when I saw that. I thought that would never happen. Well, with us, it could happen. And I discussed this with a couple of people. We would own what we brought to the table. And I think any other actual formulations or new products that came out of this situation would be negotiated. But to start, the company would own whatever it brought to the table initially.
Ken, then what happens?
Well, let me talk to you about our approach at the Gates Foundation. I think this is may help address some of Kevin's points about working with the private sector. But so our approach to intellectual property is that we want to ensure that the intellectual property is used to achieve impact and charitable objectives. But oftentimes that does not mean that even if we're funding a project that we would expect, especially when working with a for-profit, that the improvements or the new formulation that's developed with our funding would be owned by the foundation. In fact, if you think about it, if we're thinking about sustainability and engagement and how we incentivize the for-profit world to work with on these charitable projects, allowing them to retain ownership of the intellectual property provides that type of an incentive and a pathway for engagement. And so typically, our approach would be that although we may fund that reformulation or a different number of doses in a vial or some other work, that would be owned by, in this case, Gilead, and they would agree that they would provide access at an affordable price for developing countries, for our target beneficiaries in developing countries. Outside of those fields, that areas, it would be, Gilead would be able to use it for any purposes we want. And this is important when we're thinking about maybe working with a startup biotech where they need to be, in order to be sustainable, in order for them to be able to provide therapeutics to developing countries, they have to be financially stable. So if there's a mechanism that we can put in place where they're able to commercialize a product in high income countries and make a profit on that, that then creates a platform where they're able to provide the drug or the intervention in developing countries at an affordable price. So in general, that's how we oftentimes think about and look at intellectual property ownership. But I will say that this is a super hot button issue, one of the biggest issues along with liability when you're thinking about negotiating these relationships.
Good points. Okay, we're going to move along to talk about the role of the NGO, which Steve spoke to a bit this morning. In this case, we have the U.S. government providing funding through an existing openly competed grant to the NGO to handle the supply chain distribution and some of the programmatic implementation on the ground. So Nina or Valerie, could you speak a bit about what the NGO's role would be in the partnership? Should they be a party to the MOU? Can they have a seat on a steering committee of any governance body?
Thanks. I think most NGOs would definitely want a seat on a steering committee and potentially a co-equal role in the partnership. For a reason that is what one of the speakers mentioned this morning about alignment around objectives of the partnership, because the NGO is participating not as a service provider, but because this partnership is consistent with their own charitable mission. And they may have done work in this area in the past prior to the partnership, that they're bringing expertise to the table. And most NGOs would feel like they have just as much to bring to the partnership as the other members. So I think that would definitely be a position they would take, that they would want to be a party to the MOU. If you know, talking about the contributions to the partnership, that could certainly be expressed in terms of level of effort and the supply chain management, gathering of data, sharing of data. There are a lot of things that could be included in the MOU in terms of their contributions. So I think most NGOs would have that sense that they were co-equal with everybody else.
The conversation that I have with my clients, first and foremost, is my clients always want to say that any grantee is our partner, and that's nice. But I talk about I am the mean one in the department. I talk about the lowercase p and the uppercase p, and so yes, they are our partners, but we just gave them a boatload of money and they need to follow the grant document. But that might be separate and distinct, and actually we try to ensure that if that same NGO is also part of a partnership that we want to be part of, that grant, it can play a role in what the NGO is doing, but there should be some other part or reasoning why that NGO is at least existing as a partner with the State Department. So we would, I don't disagree with anything that Nina said, that there is a role to be played, but we have to understand which role that NGO is playing in that partnership as the grantee of the department.
You can tell this one comes up a lot. All right. We'll talk a little bit about data collection now. So the NGO is going to be doing a lot of the monitoring and evaluation, including the data collection analysis. So again, going back to kind of an intellectual property question, who owns the data that's collected? Do each of the parties have a right to publish on the results?
Well, with respect to U.S. government grants, and I believe the fact pattern has established that that is what this would be, the recipient of the funding has the right under the Uniform Guidance and the prior assistance regulations as well to own all intellectual property that is developed or created during the performance of the grant. And specifically with respect to an agency like USAID, there are responsibilities to deposit that data in the development data library and deposit intellectual works in the development experience clearinghouse. So there is always a responsibility to share the intellectual property that's been developed with the federal government. In terms of these partnerships, the public-private partnerships, I think NGOs' positions would be, that sort of sharing of data would certainly be just as appropriate with all members of the partnership. I know some issues have come up for some of my clients when we have governments as part of these partnerships. Some governments, ministries of health, assert rights to own data for any work that's done in their countries. And then that becomes an issue that has to be addressed in the MOU, and oftentimes the entity that has that MOU with that government has to go back and request permission from that government to not necessarily assert ownership of the data, but to allow it to be shared with other members of the partnership. And to give everybody in the partnership the ability to analyze the data and to publish on the results. So that's definitely can be a tricky issue and has to be explored very carefully, and everybody's potentially prior obligations have to be understood by all members of the partnership so it can be addressed up front. This is not something you want to be addressing 6 months into the partnership when the data has already been collected. It's definitely something I always recommend we have to look at way up front.
So I think those are all excellent points, and I know it really depends on the nature of the data, where it's coming from, the type of the data. I mean, we often have issues that if data is owned by the Ministry of Health, that they're sensitive about having that data be published because it may reflect poorly on their programs. in terms of data generated from the project, we have at the Gates Foundation an open access policy now. So when we fund data directly or indirectly in a project, and that data is published in a peer-reviewed journal, we expect or we require that the data is, the article is published in an open access journal. The underlying data is made available. And this goes to the importance of having that data be transparent. One thing that we found, which I think you raised, is that different organizations have different policies, especially the government, around what are their open access data policies, and sometimes those policies don't necessarily align with, for example, our open access policy. And so there's work that goes into figuring out how to comply with all of those policies. But again, I think it's another really hot button issue in these relationships, and sometimes having that data out there, again, is critical to being able to achieve impact.
Great. Okay. We're going to talk a little bit about partnership vis-a-vis procurement, or what I might call commercialization. So this question is going to be directed to Anthony. In addition to our planned donation, both state and the Multilateral Alliance also procure drugs from the pharmaceutical company for treatment of childhood illnesses. So I want to get your view of the difference between a procurement and a partnership. When are we partnering with the private sector, and when are we contracting for their services?
Sure, and believe it or not, we could spend an entire conference just talking about the difference between procuring and partnering. In our world, we have a number of different relationships with the same entity. In one instance, the entity is a partner where they're helping to make strategic decisions. In another instance, they are what I've termed the opportunistic partner, where they are helping us with to achieve some goal. And then in another instance, they are simply providing a service that we require. And to sort of think about the difference between those, I've added a third to what you said. You mentioned the partner, capital P, and the small p, which is procurement. And then I've added a third, which is hybrid. So, I mean, I thought about it in terms of a matrix, in terms of what are the elements that help us decide where does someone fit? What's the framework that we can look at? And so if you look at it, is it simply a provision of goods and services, or is it a high-level commitment to the mission of the organization? If they fall under a high-level commitment to the mission of the organization, then more than likely they're, it's an indication that they're a partner. If it's just a procurement of goods and services, then it's probably a procurement relationship. Is there a process, some type of tender process, some type of competitive process? Obviously, that lends itself to a procurement relationship. These partnerships don't necessarily go through a process. And that's one of the criticisms, in a sense, that you hear about partnerships, which is, how did this partner get a seat at the table when this partner didn't get a seat at the table? And then if you think about those opportunistic partnerships, it's even more complicated. So if Gilead provides us with some vaccines to carry out some mission in a country, that's nice. But now we have a partnership with them, and we don't have a partnership with their competitor. And the project that we're carrying out in country, now they potentially have an advantage in that country. So these are things that we need to think about when we're thinking about this relationship. Obviously, the contract is just completely different. In a partnership, you don't really have a contract. You have an MOU that, or you have bylaws and statutes, right, that sets out the roles and responsibilities of the players. In a procurement, you have a normal contract with delivery terms, with the price of goods and service. And then in these hybrid situations, you have something even different yet again. You have an MOU with some aspirational goals about how the partner is going to use its expertise and bring that to the table to help us achieve our goals. Obviously, there's a fee involved when it's a procurement situation, and when you have more so the hybrid the hybrid situation is often about donated services, which need to be valued, as we spoke about earlier, but which also need to be carefully looked at in terms of, are those services that we need and that we should be accepting. There's a system of allocation of risk. Risks are allocated differently in each of these relationships, and those need to be considered. And Gavi has examples of all of them. And in some situations, we may have a partner like GSK, which might be on the board, but yet they may also fit in this hybrid situation where they've agreed, along with most of the other pharmaceutical companies that we deal with, to provide vaccines to countries that are graduating from Gavi at the price that they provide them to Gavi countries. And then we have, just a pure procurement relationship with GSK. So we're constantly managing all of these diverse relationships with the same people. And luckily we try to, have there are different people in our organization who manage these different relationships. So that's how we keep ourselves honest in a lot of ways.
Well, I couldn't have answered that any better myself. I think it's such an important distinction. I think whenever you're entering into a partnership, it's fair to ask yourself, is this a partnership that's leading to a procurement? And I think that's where Valerie might really caution us, that we don't want to give that perception necessarily. I think it's fair to ask what's in it for me and what's in it for everyone else in the room. Why are they entering into this partnership? Is it because they just want to do good? Is it because they want to access a market? Is it because they want to eventually make sales or profits? Is it because they want positive PR value? I just think it's important for people to understand the motivations of everyone in the room, even if they differ. A partnership does not mean all the motivations have to be the same, but I think it means you have to agree on the end goals. Valerie, anything else on that?
No, you summed up what you've been listening. The other
Valerie is my lawyer. If anyone hasn't picked up on that, I'm at Department of State.
The other situation that I've seen come up is where we have a partnership that is, different sectors of a particular community leading towards a particular goal. And one of the needs of the partnership is to fundraise. And so the partnership will find a fundraiser, make them a partner, and then that partner is going to skim off the top a fee in order to do what they're supposed to do as their role as a partner. And that's raised some concerns from the State Department's perspective, whether or not we've now given that fundraising entity a leg up in this arena by becoming a partner with them, and then that partnership is something that they're making money off of.
I just wanted to comment on something that Anthony brought up about how you may have a procurement relationship with a company, you may have a partnership relationship with somebody, you may have some other type of relationship. And I think in thinking about governance, I think from the funders, from a foundation's perspective, we have the same issues, that we are dealing with the same parties on multiple projects, especially larger companies, but even NGOs. And oftentimes the governance differs depending on the people involved in that process. And I think that can create some confusion and some inefficiencies. And so this just made me think that maybe we need to think more holistically when we're thinking about governance. and how do we more consistently deal with partners when we're working with them on multiple fronts, but on different programs?
Absolutely. We've talked across U.S. government agencies about having a standard MOU template, but it's never quite come together. Okay, I want to talk a bit about liability. So let's imagine that the donated drugs are going to be distributed and delivered through the supply chain of the country government. How do we approach liability while still protecting your organization? And does that differ in a partnership context, donated drug, versus a procurement context? So I'm thinking, what if something goes wrong with the drugs, or what happens if you lose sight of the chain of custody of the drugs? Who's responsible?
I can start. I think NGO would view this through a lens of the more traditional arrangement where either it's procured a drug or, somebody is given funding or donated a drug. NGO is going to be looking, because it would be the face of the implementer, as also participating in that supply chain and ensuring that let's say the vaccines were received in country and were stored appropriately, that there was a certificate of quality issued by the manufacturer before the vaccines came in country. The NGO is going to want to see maybe a quality assurance agreement, a pharmacovigilance agreement, executed with the donator of the vaccines to protect everybody, basically. You don't want something to happen and the partnership is vulnerable in the eyes of the ultimate recipients. So that would be a very important aspect of the legality of the MOU and the governance, to make sure that those responsibilities were addressed appropriately, and that the drug manufacturer would take responsibility. Even though the vaccines are donated, they would still issue the certificate of quality, where they would give instructions about storage, so that as the implementer, the NGO knows what rules and regulations it has to comply with. And I think there would be an additional question about would this need to be registered with the National Regulatory Authority? Has the vaccine already been approved? Who's going to take responsibility for that? So as the implementer, those would be the sort of technical and logistical issues, legal issues too.
So not the funder. It's not responsible.
The funder does not want any responsibility.
We don't want liability. And so we try to structure these transactions in that way. But honestly, I mean, this is a really tough issue for these types of partnerships, because, and I won't speak for the pharmaceutical industry, but I think that with donated drug, they have certain responsibilities to the point that they sort of release the drug, right? And they probably can't contract around those liabilities. But in terms of what happens in the field, you're going to have, in this model, in this scenario, it's the NGO who's on the ground. So there's lots of risks, right? I mean, there may be a problem in how the drug has been stored and handled. You may have people working in high-risk countries to try to vaccinate children where there's all sorts of risks. And you think about, okay, well, I mean, if the NGO is responsible for doing those things, then sort of logically it would make sense that the NGO is liable. But if you're talking about an NGO and you're asking them to, defend the other parties and hold them harmless in this arrangement, the NGO is unlikely to have the resources to be able to do that. So I think you have to think about other risk mitigation strategies, but I think it's a very challenging issue, and part of the risk mitigation could be insurance, it could be doing due diligence, but if anybody has the magic answer for how you solve this, we'd love to know.
And it's not just look to the parties with deep pockets, I assume.
Yes, I shouldn't be looking at the parties with deep pockets, but that's why from the foundation perspective, we try to be clear that our role is that we are providing funding and we're not actually involved in operationalizing or implementing the strategies.
I think maybe just to add to that, for many of the relationships that we have in terms of looking at liabilities, we certainly try to ensure that the contracts that we enter into, both our procurement contracts with pharmaceuticals, make sure that they will indemnify and hold harmless any of the parties involved in providing funding for the program. But of course, as you say, that's specifically for products liability. And if something goes wrong in country due to mismanagement or just, electricity went out, then we also try to ensure that we contract with the governments to make sure that they're responsible and hold the parties harmless. Of course, this doesn't prevent anyone from bringing a class action lawsuit in New York, which is, what we sort of think about when I try to sleep at night. But the reality is that in our situation, the NGO would be implementing a program on behalf of the government because it's talking about vaccinations. So we would ensure that in this scenario that we at least have the government involved, which would have deeper pockets, maybe not tremendously deeper pockets, but deeper pockets than the NGO. One thing that's quite interesting is you often see, sometimes in these public-private partnerships, is that many of the players actually have privileges and immunities. And so what happens when you have a relationship and all of the state actors have privileges and immunities, so they exercise those privileges and immunities and they drop out. All of the multilateral international organizations have privileges and immunities. They exercise those and they drop out. And so you're left with, like the foundations of the world, which don't have privileges and immunities, but they do have insurance to cover them, at least for defending the cost of an initial litigation so that it can be pushed back to whatever party should be responsible for it.
All of that boilerplate language that appears in your contracts has real effect, and I think this might make us all read it a bit more closely. Okay. Anthony touched on this point earlier, but I want to pick it apart a bit more. So let's imagine there are actually 3 pharmaceutical companies who manufacture this vaccine. How do we deal with competition or a perception that we're not giving preferential treatment or showing favoritism to one company over another? You spoke to the fact that, if we were to issue a tender or an RFP, it would be inherently competitive. But in a partnership, that's not often the case. We don't have to put out a tender and ask every pharmaceutical company to apply. We've chosen to enter into a partnership with this one. So how again, it gets at the partnership versus procurement, but specifically in the competition and preferential treatment space?
Well, that is the first thing that we ask. That's why we have the internal discussion first with the program office is, why did you pick this partner? Why are there other partners, potential partners in this same sector? What dropped them out? Why are you only speaking about them? Because we cannot be seen as giving preference to any individual or any company. We are the federal government and we offer equal opportunity to everyone. And so it is critical that the program office explain that the objective criteria were applied in each instance where a private sector partner is engaged in a potential partnership with us. And if they can't define what those objective criteria are, we will tell them that they're done, that there is no partnership for us to join until they can come up with those criteria for how we got there.
Yeah, I think this is difficult for this case because it's hard to imagine a situation where a pharmaceutical, and maybe you can enlighten us, but it's hard to imagine a situation where a pharmaceutical company would have competitors and would make a donation and not have ulterior motives. So what you're looking at in this situation is to think about, well, what are those ulterior motives, and how can we deal with them in the MOU, or how can we address them up front? Because if the motive is to be the first entrant into a particular market, that has real meaning because of potential presentation and just presentation of a vaccine, delivery of a vaccine, and just the antigens that the vaccine may address may be different from the other ones. So just the nature of a relationship where there are other competitors makes this type of partnership quite complex, as opposed to a partnership where you have only one manufacturer of a vaccine. So for example, if there is a new Ebola vaccine, you can imagine that situation where it's much easier to enter into a relationship because you've already addressed all of the questions that have been that are going to be asked by state and your other donors. So this is a very complex situation to be in, because you may have a very specific goal that you want to address, and there could be a very clear reason why this manufacturer is appropriate for this scenario.
Could be that the manufacturer just has the very best drugs and wants to get them out to people.
The one thing that we also look at is not just they want to be the first into a sector, but also people like to associate with the federal government and say, look, the federal government loves us, they partnered with us, you should buy our drugs. And so we also are very, very careful about whether or not there's an endorsement issue, whether it's overt or covert.
And I would actually say the same for Gavi, because countries that we deal with have a very high opinion of Gavi very often, and so organizations want to associate with us. Countries want to associate with us as well, to maybe increase their brand within the country.
I don't know if we're going to open it for questions, but because the government that's represented here is the United States government, I just wonder if there are other government representatives who might have a different opinion or a different experience in this scenario and might want to weigh in.
We'll definitely open up, and that is a perspective I will be very keen to hear from, is national governments. Really, they should probably be up here with us now. We just have one or two more questions, and then we'll open it up to the audience. Would be remiss in a governance panel to not talk about the governance structure, whether that's a secretariat or a coordinating committee. So that's in any partnership I've been in, that's a key question. How do you create it as an independent organization, or is it nested within one of the partner organizations? What does the voting power look like? Going back to some of Ken's earlier comments, it's not quite like a venture capital model. How do you resolve conflict? How do you exercise control over your resources versus other people's resources? And how do you ensure that you're representing the fiduciary duty of your own organization vis-a-vis that of the partnership itself? I think that's probably something everyone has a comment on.
I'm happy to begin. I think some of this starts with, and feels so maybe my social worky stuff comes out touchy-feely, but at the core is a group of people, a group of organizations who really are interested in advancing health, in advancing well-being. So I think ideally, ostensibly, people come to the table with good intention, and hopefully with the commitment to doing what's best to making this happen. Now, of course, rare is the person who can divorce her or himself from obligations to her or his organization, and I don't even know that it's practical to do that. But ideally, it's a group of people, a group of organizations who come together thinking about how to build a structure, a set of systems that are going to, at the end of the day, get the vaccines, in this case, get the medications to the people who need them, and putting organizational ego and aside. So I think that's the starting place.
Maybe just to say, I've done a lot of work around structuring various, structuring Gavi in various different ways. I've been there for 12 years, and Gavi started out as, if we look at the matrix that Mark provided earlier, as a bit of a handshake organization, a pure alliance between parties that were interested in doing good for global health. And moved because the organization was in a very different place and realized that the project that had started was a longer-term project, and being nested within an international organization didn't allow the project to really meet its goals, and didn't allow it to operate as an independent entity. Operating as an independent entity allows you to do things quite differently, because you're able to enter into creative type deals as an independent entity, as an independent, nimble organization that you might not be able to if you're nested within WHO. Being nested means you have to follow the rules and procedures of the organization in which you're nested. And so in consideration of establishing these organizations, it's really important to consider how you initially want to establish yourself, but it's not something that has to stay. Both the Global Fund and Gavi changed the way that the organizations had initially started out and became independent organizations. And I just did a secondment with an organization where they went through an entire restructuring as well and changed the way that they operate. So organizations move along that path from a handshake to independent organizations, and I have a conversation at least probably once a year with an organization that is looking to move outside of a nested relationship, and they want to know, so what was Gavi's experience and how did you do it? And I think the most important thing is actually to have these conversations, because if you really have to understand all the complexities around the issues that need to be thought about as you're moving along from a nested organization into an independent organization, because there are also some negatives with being an independent organization that you have to consider.
I would just add, looking at the fact pattern presented here, I think when you're talking about pros and cons of secretariat structures, decision-making authority, all of those issues, you have to be very clear in defining the objective of this particular public-private partnership. It's not probably going to be long-lasting like Gavi. It's just very circumscribed. It's donating, getting 1 million vaccines out to children in either a country or a particular region. And I think if you define your objectives clearly, that can lend itself to a productive discussion about a secretariat. And if it's a very limited objective, then yes, everybody should have an equal seat around the table. If you're talking about public-private partnerships that have broader objectives and are not clearly limited in scope, I think these issues become very difficult to navigate through. But with a more limited and objective, I think everybody would probably agree that there should be, co-equal decision-making, things like that.
Anyone else? I'll ask one final question that just kind of picks apart the presumption, Douglas, that everyone does necessarily agree, even if you agree on the end objectives. So in this case, let's imagine that the partners agree on the objective, but they're divided on the approach. The NGO and the multilateral organization really want to ensure broad coverage, and they're willing to take great efforts to find the hardest to reach children in the farthest to reach places. And the State Department is really interested in impact. So they want to be a little more focused in who they reach and just get as many children in a concentrated geography. And the Philanthropic Foundation is thinking about sustainability and wants to ensure that there's a plan for absorbing the costs in the future. And the pharmaceutical company cares about scale and wants to be sure that this, has a ability to reach all. So this is, none of those are necessarily in conflict with the objective, but you still have to find a way to harmonize the philosophical and the strategic and the cultural differences across the sectors. Thoughts?
So sure, I think this is a very realistic scenario. This comes up all the time. And I think one thing that it reminds me of is, and one of the articles I was reading that was in our pre-read materials, one of the lessons learned from looking at these partnerships was to think first. And so I would say that this is a key reason to think first. So before the investment is made, before you put together the MOU, I think it's important to, number one, be transparent about what are the different motivations, and to be very specific about what the work plan is. So what are the roles and responsibilities of each party, and to have a lot of discussion around those things. And at that stage, see if, even though you have some different objectives, that the overall goal is important enough that people are going to come together and find a way to work together, but to really get these things out on the table as early as possible. So when we're making investments, we have a strategy that we've thought out. We would probably know the geographies that we would want the vaccine to be delivered in. We would know whether we're going for high impact, and we would discuss that to see if we're aligned with the partners. Now, obviously, there will be things that come up in the relationship that were not anticipated. And so I think it's also important, as people have mentioned, when you're putting together the MOU and the governing documents, to think about, well, what is the dispute resolution process? What is the change management process? And to really think about those scenarios before you actually set up the organization.
Anyone else? All right. I want to start by opening it up to the floor, but I'd like to see if there are any representatives of country governments who would like to just kind of voice their opinion before we turn back to questions to our panels. Yes. Mr. Pate.
Thank you. Well, I'm not representing any government, but I just thought I should ask the panelists to clarify. My name is Muhammad Pate. Where there is conflict between national laws and the agreements that this partnership structure, how do you, in terms of maybe not your respective institutions, but how should these global partnerships actually address? Which one will be supreme? Where there is divergence, because you're working in the context of countries with laws that govern processes and how things are done, procurement and other aspects of it. So where there's divergence, which is supreme? US law, source country law, global law, where is that resolved?
Usually, an MOU would have language such that similar to each party must act in compliance with its local laws are any laws that are applicable to it. So although the MOU itself may be under Swiss law, if the organization is established in Switzerland, the parties that are part of the partnership are operating all over the world. And as you say, they are subject to local laws, national laws. But it would normally be identified in the MOU that maybe not all the time, but often it's identified that the parties would have to adhere and would be expected to adhere to their individual national laws, irrespective of whether it was the State Department or whether it was an NGO in an implementing country or whether it was the Gates Foundation in the U.S.
Yeah, I think that when I first heard the question, I was thinking one thing, and then as you were explaining, I agree. It depends on the role of each partner, and I think that those would be dictated in the MOU itself. But then there's also, so we have some pretty complicated, we are members of some pretty complicated public-private partnerships where the governing organization is actually a legal entity of its own and is incorporated in a country, and then that secretariat must follow that country's rules and regulations, which causes the United States some concern, particularly if we have a person on that secretariat, because that person, if they're acting in their capacity as, as an official government individual, they cannot bind the United States government to another country's laws unless Department of Justice tells us we can be, which they won't. And so we definitely pay attention to the structure of the partnership, the structure of if there is a governing entity, and then what we're doing in furtherance of the ultimate goal. If we're the ones who are in charge of procuring things, then we would follow the United States rules, the federal government rules on procurement. But we also would make sure that we're not overtly violating the in-country rules as well.
Justin? No. Okay. Any other questions?
Thank you, Lauren. Justin Custer with Medtronic, and I don't think I'm smart enough to formulate it as a question, so I'll make it as a comment, and hopefully you'll react. So I wanted to bring the conversation back to the notion of procurement and competition when it comes to PPPs. And I guess my comment is that, well, again, Medtronic is a medical technology manufacturer, so parallel, but definitely not the same as a pharmaceutical or a vaccine manufacturer. And I guess one of the main things that we have to bring to the table when we're delivering our product to market that is a clear differentiator in terms of competition is the notion of service as a piece of that. But I think the other thing that sticks out to me that we don't often talk about when we're talking about PPPs, and I'll borrow Anthony's term about opportunistic PPPs especially, is that they are often very entrepreneurial. And the reason a manufacturer or a company in general even wants to get into that PPP is that the PPP itself is making a market that doesn't exist, right? And the reason that the manufacturer or the company can't do what they want to do to sell their product is because the market doesn't exist, right? There are no buyers and sellers yet. So I think Nina answered my question a little bit already, but I think the importance of identifying the scope and especially the intention, and it goes back to everyone's points about objectives of the partnership. But I don't think it's a thing that we talk about enough, but the notion that especially opportunistic PPPs are creating a market. And so Valerie's comments about being concerned about entering into a procurement, they ring very hollow for me, especially if you take into consideration that from a competitive perspective, that company is making an investment in creating that market. And so what, I guess, just how do the players in the partnership take that into account? Thanks.
So the conversation you just had is one that I had with Lauren like 6 weeks ago, and it is a problem for at least for my agency. I've never heard anyone admit that these could be opportunistic or entrepreneurial, but there are certain times where we will look at them and say, this is not a place where the State Department should be playing. We should let the private sector and the NGOs work this out, and then if we come to a point where it is appropriate for the department to be at least a participant in something that has developed out of that initial partnership, then that's where we should step in. But my personal view, not speaking for the State Department, not speaking for the legal advisor, is that opportunistic PPPs are not someplace where the State Department should be.
I mean, I would say that from a private foundation's perspective, I mean, I talked earlier about those scenarios where there's the ability for the for-profit company to, create a commercial market in developing countries, but also provide products at an affordable price in developing countries. I mean, one thing that we have to be careful about is there is a line at some point that we can't cross, and that is that we are a charitable organization, and our funds have to be used to further charitable purposes and not create, too much private gain. So I guess in that scenario, these opportunistic PPPs, I mean, one thing that we would look at is, are we really serving charitable purposes, or are we serving more commercial purposes?
I would say, first of all, thank you for your honesty. It was a really good question and well articulated. I think for Gavi, we also recognize that, yes, it does often create opportunities for an organization, but on the other side, it's also sometimes finding very, very creative ways to tricky problems that we haven't been able to solve for years. And that's why we're interested in these types of opportunities. And we have a framework by which to evaluate them. And so does the Global Fund, and that framework has gone through our governance process. So the governance team is not the governance team, but our leadership team has an interest in finding solutions to very hard to tackle problems. And it's these innovative companies sometimes that are finding a solution. If we can do that in a creative way, I think everybody at the end of the day would be happy. If we can find some very, very creative solutions to difficult problems. And if you watch YouTube, you'll see some, very interesting things around clean water and interesting things around getting vaccines to hard to reach areas, ensuring that you have information around children that have been vaccinated in a country, around data. And these are a couple of issues that we deal with, and we're always looking for creative solutions to resolve this. And it is a balancing act, as Kenneth says, but as long as you have some framework by which to evaluate and judge the opportunities that are presented to you, and it's a fair framework that allows other parties to participate, and it's an open framework that has transparency, then I think it's something that ultimately leads towards towards the mission of the organization, and at the end of the day helps to vaccinate more children in more countries.
I think that's right, and the opportunity doesn't necessarily have to be nefarious. I mean, it could be that you're bringing pharmaceutical companies to the table, actually challenges them to do better, to take a look, and you know, just speaking for our own company, I know for a fact that there have just been opportunities where through such engagements, our execs have had an opportunity to see a problem in a way that they otherwise would not have seen, and say, we can help here, and we can help in a way that's that is affordable and that benefits the public's health. And I will say, as someone who worked in government and had this argument with your counterparts, Valerie, that I do think there's a role for the United States government in creating that as well, in especially when you think about public health, when you think about infectious disease, when you think about part of what we do need to create is getting more people on medications that are going to save their lives, that are going to theoretically and hopefully end an epidemic or end epidemics. There is a role there.
Okay, we only have about 5 minutes left, and I see about 4 questions, so I'll ask that you keep them quick. Kate?
Thank you. I'm going to try and be quick, but I have 2 comments as well. One is that I'm very much looking forward to the partnership forum on small p versus big P, because I think that's something that comes up, the word partnership, I struggle with as well, having most recently been the director of partnerships at PSI, an NGO. And it's difficult to be a partner if you're being paid. So trying to understand sometimes where you go between partner and procurer is interesting. I also want to get back to the question of value. And I think this comes to the idea of not every partnership these days is just money-based. There are lots of partnerships that have the intangibles within them, whether that's expertise, the value you bring because you're in country, the government connections you may have already, the product that you have. It's not just about your hourly rate. And someone on the panel mentioned the fair market value formula. And I think that's something that, again, probably needs further discussion, because I think it's something people really struggle with, again, especially if you're at the NGO level, where you really have to think about the tax implications and your 501c3 status, how much money, how much time you're getting. And then just finally, just to the comment about, is it okay if this person's come and are we giving them a leg up in the market? I think often with partnerships, the way that it's worked for me over the past 20 years is really the willingness of someone to put their hand up and say they want to do this. And so really, first in market is also first to action often. And I think there's got to be a bit of balance there in terms of, hey, they're willing to do it, we're going to work with them. If others want to come in later, that's great. So really just a question about value, but I appreciate there was lots of comments there too.
I agree with all your comments. I don't know if anyone has a response.
You actually gave me insight into a way to look at it so that I'm not like White House counsel. That I can, if there's a way to structure a partnership such that if it is indeed some way to allow for other similarly situated private sector entities to join either immediately or as the game goes down the field, that might help us in terms of.
And I can assure you the NGO community will be very happy for as many private sector to come in as possible. So
that's great. Jeff.
Thank you. I just wanted to comment on this question that Justin raised, and also suggest that isn't as much of a conundrum as it seemed to be. That is, how can governments actually be involved in partnerships that are creating markets that might seem to give commercial opportunities to some of the private sector partners? I would just point out, as a couple of you have alluded to, that the U.S. government has the MCC, USAID has been doing market shaping for the last few years. You've got TDA, you have the Department of Commerce, OPIC, EXIM. There are many ways in which the U.S. government is trying to do exactly that. And also PEPFAR, as I don't have to remind Lauren and others in the room know as well, that PEPFAR over the years through the Partnership for Supply Chain Management together with the U.S. government's contributions to the Global Fund, has actually been responsible for creating one of the largest markets in Africa and other parts of the developing world for antiretrovirals. So, but the answer to this, where it seems to be a conundrum or a challenge, actually, I think Anthony spoke well to this, that as long as you go back to the first principles that everybody's been talking about, when you design a partnership for a specific purpose, that you disclose interests, that you're open about it, that there's that transparency, and you try to create a fair opportunity for people to participate and to benefit from it, then you can manage those issues. But you know, it just struck me that you know, we really are trying to do both things, and creating those markets actually does help to accomplish the good that many of these partnerships are set up to do. So I don't see those as in conflict. It's just a question of using these principles to manage those issues.
Can we get to the last two questions? Okay. Brenda.
So I appreciated Anthony's distinction between ethics and conflict of interest and the different approaches that are required in managing those. I wanted to just note a third or relevant component of that, which I think is also different, which is risk and risk management. You know, my experience with our lawyers in terms of trying to put together, whether they're frameworks of agreement or any documentation related to partnerships and initiatives, has been what I perceive as this desire to manage to zero risk. And perhaps I'm unique in that experience, but, and I don't want to overstate it, I don't want to be dramatic, but there's almost this underlying paranoia about that agreement. So I'm curious to know from the lawyers if you have been accused of this, and or more importantly, how you think about risk and what your objectives are in terms of managing that risk when you're putting together these agreements.
So at the Gates Foundation, we don't manage to zero risk because I think that would severely impact our ability to have impact. So our focus is very much to be solution focused, and certainly there are risks, but again, it comes back to balancing those risks. I mean, there are, just as with the technical work we're doing, there's a high degree of risk. In some cases, there may be a high degree of risk, but the potential reward and impact on our target beneficiaries is such that it's worth taking that risk. So in my experience, both working at the Gates Foundation and being in the private sector for many years, it's not, I didn't see my role as managing to risk, but actually finding solutions that would move programs forward.
And I would just add to that, I think my role often is, as you've described it, I'm like the voice of doomsday, what about this, what about this? And I persist in that just to make sure my clients understand